Hey everybody, Matt Barton with this week's Broker Minute or Two. If you're at the convention, hope you're having a good convention this week. Hey, question comes up from time to time in regards to power of attorney um, signatures on a contract. And there's basically two scenarios I wanted to cover briefly today. The first scenario is when one of our clients, buyer or seller, puts somebody in place as a power of attorney. Simply put, it just means they have the legal power to sign on behalf of somebody else. There's basically two flavors of power of attorney. There's limited power of attorney, which gives them only the right to sign for certain things, or a general power of attorney. A lot of times when somebody's either physically or mentally incapacitated, but usually there's a court order required to get that if somebody's suffering from incapacity. Think older person maybe who got dementia and doesn't have their items in a trust with a trustee. Okay, so what I want to talk about today is the two scenarios. One, if you're doing a transaction with somebody signing as a power of attorney for one of the clients, whether it's limited or general. And the second one is, what if we get asked as a licensee to take on power of attorney privileges? So pretty important things. Let me share my screen. All right, the first thing to notice is that when we're dealing with the power of attorney, and I've run across this a couple times recently on our own transactions where somebody says, well, we have a power of attorney. My first question is it notarized? And they say, well, no. I'm like, well, then you really don't have uh, an effective power of attorney. As it states here in the highlights, a power of attorney needs to be signed in front of a licensed notary public in order to be legally binding. Why? If you look up above, well, actually, if you look just on the tail end of that, it says the notary public is a representative of the state government, and their job is to verify the identity of the signer and to ensure they are signing under their own free will and to witness the signing. Kind of makes sense, right? Otherwise, people could just fill out a paperwork and say, I have a power of attorney and sell your house without you knowing. That's a facetious example, but it kind of demonstrates the point. Okay, then I'm going to bump to our administrative rules from the Division of Real Estate in the state of Utah to cover how do we handle this and if we're asked as a licensee. So in the administrative rules, rule number 19, it says before signing or initializing a document on behalf of a principal in a sales transaction, obtain prior authorization in the form of a power of attorney executed by the principal. Now this applies to whether we as the agent are being asked to do it or somebody else, right? And then it goes on further. I have highlighted item number C is an important one. Whether it's us as a licensee, let me just say this. Us as a licensee signing as a power of attorney is a really bad idea in almost every situation, and I will come back to that. But item C says that if you are in a transaction with a power of attorney, then you have to attach the said power of attorney to any document signed or initialed by the individual on behalf of the principal, whether you're a licensee or not. And then it talks about how we as a licensee should sign. Well, this also generally applies to the power of attorney. So let's say I give power to my son to sign on my behalf. I'm not a realtor. That would be my name, Matt Barton, by, and then Trevor Barton, my son, attorney in fact, and then I'd have the attached legal document notarized showing that that person has the right to sign legally on my behalf. Same thing with initials. I know this is extra work, but this is what is required by the Division of Real Estate when we fill out contracts so that we fulfill our fiduciary of reasonable care. Okay, so those are the logistics. I want to come back to, even though the Division of Real Estate says this is how you could do it if you as the licensee were signing on behalf of a client, I recently had this conversation with one of the lead investigators at the DRE, and the first words out of her mouth is, don't do it. So even though you can do it, what the problem is it puts you as the licensee and your company squarely in the middle of the risk game, meaning if something goes wrong, you get lumped into it. So if somebody is physically incapacitated and can't sign, they can always make the case that if you sign something on their behalf, a good attorney could make the case that, yeah, they were physically incapacitated, but that also affected their mental capacity, and you didn't do what they would have done in the situation. And all of a sudden, you're defending your actions and fending off potential civil litigation. So it's my recommendation as your principal broker, in harmony with the Division of Real Estate, that if somebody asks you to be a power of attorney on a transaction, please don't. If you feel like it's compelling that you need to, please have a conversation with me before you ever go down that path. It's rarely, if ever, worth it, and there's almost always an alternative that keeps you, me, and the company out of the risk game. So I hope that helps. Power of attorneys are great things for certain situations. You just need to make sure that you navigate them correctly. I hope that helps. Have a great week, and we'll talk with you soon.